She saw a woman in a parking garage. She saw natural hair and work clothes and a tote bag that had seen better days. She saw someone who looked to Officer Dale Pruitt like she was about to become a problem. What Officer Pruitt did not see was the Federal Judicial Commission folded inside that tote bag. She didn't see the 16 years on the bench, the 312 published opinions, the two landmark rulings that had been cited in cases before the United States Supreme Court. She didn't see the woman who had spent 22 years building one of the most formidable legal minds in the Eastern, the district, who had earned her seat through work that most people in her building could not have survived, and who was now walking to her car after a 12-hour day with a dry cleaning receipt in her hand and approximately zero patience remaining for the particular flavor of arrogance standing between her and her vehicle. Officer Pruitt thought she looked like a problem. She was about to find out what a problem actually looked like. The Mercer County Judicial Complex parking structure sat on the east side of downtown Caldwell, a 5-level concrete building attached to the main courthouse by an enclosed bridge on the 3rd floor. It was 8:40 on a Thursday evening in November. The building itself had mostly emptied out by 6 clerks and paralegals and junior attorneys cycling out with their bags and their takeout containers, and the particular exhaustion of people who work hard in service of a system that does not always work hard in return. The judge's reserved level was on the 4th floor. Level 4 had 8 designated spots, a security camera at the stairwell entrance, and a call box that connected directly to the courthouse marshal's office. It also, on this particular Thursday evening, had Officer Dale Pruitt. Pruitt was 33 years old, 6 years on the Caldwell PD, and had been assigned to courthouse security detail on a temporary basis while 2 permanent officers were on leave. He did not like the assignment. He had applied for courthouse detail 3 years ago when it came open and had been passed over, which he attributed, with the specific resentment of a man who does not examine his own record closely, to politics. He had spent 6 years in the department and had collected, in those 6 years, 9 use-of-force complaints, 4 citizen misconduct reports, and a single formal reprimand that had been reduced to a notation after his union filed a Dix grievance. He was not what most people would describe as a careful officer. He was, however, a confident one. He believed in his own authority, the way some men believe in luck, absolutely, without evidence and in the face of substantial evidence to the contrary. He had been told that Level 4 was restricted, authorized personnel only. He had interpreted this as an instruction to challenge anyone he did not personally recognize, which was everyone, because he had been on this assignment for 11 days and had not learned any of the judges' names or faces beyond the 2 who had nodded at him in the elevator. Honorable Diane Osei Mensah had been a federal judge in the Eastern District of Caldwell for 16 years. She was 51 years old, 5 feet 4. With natural hair she wore in a low twist when she was on the bench, and loose. When she was not on the bench at 8:40 on a Thursday evening. She was wearing a charcoal blazer over a gray dress, carrying a tote bag stuffed with the transcript review she had been working through since noon, and holding the dry cleaning receipt she had forgotten to use for the 3rd week running. She looked like a professional woman at the end of a long day. She looked like someone's boss. She looked, to anyone paying attention, like a person who had been in this building so long she had stopped registering the furniture. She did not look to Pruitt like she belonged on Level 4. She had parked in Spot 4, which had her name on a placard she had been looking at for 16 years. She was walking toward it with the muscle memory of a person who does not need to think about where she is going. She had her keys in her hand. She was thinking about the transcript. She was thinking about the motion she needed to decide on by Friday morning, a Fourth Amendment suppression issue that had been argued sloppily by both sides and would require her to write her way to clarity herself rather than leaning on counsel to do it. She was thinking about that when she heard the footsteps behind her. And then the voice. Hey, the word landed like a thrown object. Blunt and aimed. Hey, you, stop right there. Judge Osei Mensah stopped. She turned around. Officer Dale Pruitt was standing at the end of the row, one hand on his belt, the other holding a flashlight he had not turned on. He was looking at her the way certain people look at certain other people in certain spaces, with the particular expression that communicates, before a single word of substance has been exchanged, that the primary data point is not conduct, but presence. This level is restricted, Pruitt said. Authorized personnel only. I need to see your access credential. Judge Osei Mensah looked at him. She had spent 16 years reading people in high-pressure situations. She was very good at it. She read Pruitt in about 4 seconds. "I'm Judge Ose Mensah," she said. "I'm in spot 4. I've been in spot 4 for 16 years. Pruitt's expression did not change. "I don't have you on my list." "I'm sure you don't." Her voice was even, not hostile. The voice of a woman who is tired and choosing to be patient for reasons she is beginning to reconsider. "The list you have is a daily visitor log. The permanent judicial assignments are in the building directory. My placard is on the spot." She gestured toward her car. "You can read my name on it from where you're standing." Pruitt did not look at the placard. "I'm going to need to see a credential," he said, "or you can wait here while I call it in." "You don't know who I am," she said. It was not a question. It was an observation delivered without performance. "No, ma'am, I don't. That's why I'm asking for a credential." She looked at him for a moment. She reached into the tote bag. She produced a leather portfolio, the kind that holds a judicial commission on one side and a building access card on the other. She held it out. Pruitt looked at it. He squinted. He was not close enough to read it. He did not move closer. He said, "What is that?" "My credential. I need to see it properly. Bring it here." She looked at him. She did not move. What happened next lasted approximately 90 seconds and would be described by 4 separate individuals who witnessed it, in 4 separate statements taken over the following 48 hours, in terms that ranged from unprofessional to the most brazen thing I have seen in 22 years of working in a courthouse. Pruitt walked toward her, not to read the credential she was holding, to establish proximity, to use the size differential, the uniform, the flashlight, the belt equipment, the physical language of authority over a woman who, in his assessment, had not provided a sufficiently deferential response to his initial challenge. He had used this approach before, 9 times, according to his use of force complaint file. The approach involved closing space, lowering his voice to a register that required the subject to be physically close to hear it, and introducing language that carried just enough ambiguity to be deniable in a report, while being entirely unambiguous to its target. He got within 4 feet of her. He looked at her with the full weight of his assessment. "Lady," he said, his voice dropping, "I don't know what county you think you're in, but in this building, you don't get to walk around wherever you want because you feel like it. Now, I don't know who told you this level was okay, but whoever it was, they were wrong. So why don't you save us both some time? Go back down to visitor parking on level 2, and we can all go home." He paused. He let the pause do its work. "Unless you'd rather I call building security and have them sort it out. Your choice." Judge Osei Mensah looked at him. The expression on her face was one that the attorneys who appeared before her in courtroom 14 Bites would have recognized immediately and would have described, if asked, as the look that means something is about to happen and it is not going to be pleasant for the person who caused it. It was not an angry expression. Anger was loud and imprecise and wasted energy. This expression was something quieter and considerably more focused. It was the expression of a woman deciding, with complete calm, exactly what she was going to do next. She put the leather portfolio back in her tote bag. "I'm going to give you an opportunity," she said. And her voice was the same voice she used when an attorney had made an argument so procedurally incorrect that she needed to give them a moment to reconsider before the record captured them, committing to it. "I want you to go to the building directory, which is on the wall next to the elevator you came up in. I want you to find this level's parking assignments, and I want you to find my name, which is on a placard that has been on spot 4 for 16 years. She picked up her tote bag. "And then I want you to come back to me and tell me what you'd like to say." Pruitt looked at her. His jaw shifted. He made the decision that had defined his 6-year career and 9 use-of-force complaints. He decided that the situation required escalation rather than investigation. "Ma'am, I'm not going to the directory. I'm asking you to produce a credential or vacate the level. You've seen my credential. I've seen a piece of paper you pulled out of a bag. I'm a federal judge," she said. "I hold a judicial commission issued by the President of the United States. The credential you are refusing to look at contains my commission number, my district assignment, and my building access authorization. I am standing in my assigned parking spot. And you," she looked at his badge, "Officer Pruitt, are standing between me and my car on the basis of nothing more than the fact that you don't recognize my face." Pruitt felt the conversation going somewhere he didn't like. He did not know exactly where it was going. He did not have the context to understand the full geography of where it was going. But he felt the ground shift, the way it sometimes did, and he responded to that shift the way he always responded, by pressing harder. "I don't know if you're a judge," he said, and his voice now had something in it that had not been there before. Something that he would, in a statement 3 days later, struggle to explain without using words he did not want on the record. "For all I know, you picked that thing up at a print shop. So either you show me something that proves who you say you are, or I'm going to need you to come with me to security." The leather portfolio, he had seen it. He had refused to look at it. He thought it was a piece of paper. He would not think that for very much longer. What Officer Dale Pruitt did not know, what he could not have known, and what would not have stopped him even if he had known, because men who operate on confidence rather than information rarely stop even when the information is in front of them. Was that the case number currently sitting in the active docket of the Honorable Diane Osei Mensah, Eastern District of Caldwell, Federal District Court, was United States v. Pruitt D., badge 4417, Caldwell PD. He had filed an appeal of his most recent misconduct determination 9 weeks ago. The appeal had been assigned by the district's random rotation 2 weeks later. It had been assigned to her. She had not known, when she opened her docket that morning and found his name, that she would see him in her parking garage. 8 hours later, she had known his name only as a case number, a complaint file, a set of facts in a disciplinary record that she had reviewed with the same methodical care she brought to every matter before her. She had not yet ruled. She had not yet issued an order. The matter was pending properly, without prejudice, in her docket. She had recused herself from nothing because there was nothing to recuse herself from. She did not know Dale Pruitt. She had never met Dale Pruitt. She had been entirely and scrupulously neutral on the matter of United States v. Pruitt D. She was considerably less neutral about him right now, but she was also, and this was the thing that made her the judge she was, a person who understood the difference between her personal response to a situation and her professional obligations within it. Those two things were not the same. They would never be the same, and she would handle them accordingly. She took out her phone. She called the courthouse marshal's office. The call connected in 4 seconds because the marshal's office staffed a late shift line precisely for situations occurring in the building after hours. She spoke for 30 seconds. She stated her name, her location, and the nature of the situation. She did not raise her voice. She did not describe Pruitt's conduct in terms beyond an officer on temporary detail who is declining to verify my credentials and is requesting I vacate my assigned level. She did not mention that his name was in her active docket. That was not information that belonged in this conversation. She hung up. She looked at Pruitt. "The marshal's office is sending someone down," she said. "They'll be here in approximately 3 minutes. You can use that time however you'd like." Pruitt crossed his arms. "Fine, we'll wait." "Yes," she said, "we will." They waited in silence. Pruitt, who had spent 6 years using silence as an intimidation tactic, discovered that silence did not work the same way on a woman who spent her days using it to let attorneys understand that they had said something wrong. The silence in that parking garage was entirely hers. He was merely present in it. The elevator opened at 8:53. Chief Marshal Renata Chambers stepped out. She was a tall woman with 28 years in federal law enforcement, 15 of them in this building. She knew every judge on this floor. She had known Judge Osei Mensah for 11 of those 15 years. She had attended the ceremony when the judge was elevated to senior status. She had seen her picture on the wall of the building's judicial honors corridor every single day for a decade and a half. She saw Pruitt. She saw Judge Osei Mensah. She understood the situation in approximately the time it takes to read a single sentence. "Your Honor," Chambers said, walking directly to the judge, "I am so sorry. Are you all right?" "I'm fine," Judge Osei Mensah said. "I'd like to go home." "Of course." Chambers looked at Pruitt. Her expression was not the expression of a superior officer about to have a constructive conversation. It was the expression of a person who has been called away from something important to deal with. Something that should not have happened. "Officer Pruitt, Chief Marshal, I know what you were doing." Chambers's voice was level and completely without warmth. "I need you to step away from Judge Osei Mensah's vehicle. I need you to go to the marshal's office on level 2. I need you to wait there. And I need you to not touch anything or speak to anyone until I arrive." Pruitt opened his mouth. "Now," said Chambers. He went. The elevator closed. Chambers turned to Judge Osei Mensah. She started to say something. The judge shook her head very slightly. "I know," the judge said. She was looking at her car. At spot 4, at the placard with her name on it that Pruitt had never looked at. It's all right. I've got the early session tomorrow. I need to go. Chambers watched her get into her car. She watched the taillights recede down the parking structure ramp. She stood there for a moment in the empty level, in the specific quiet of a building after everyone has gone, and felt the particular weight of a wrong that had been committed in a place that was supposed to be above this kind of thing. In front of a woman who had spent her life working to be above the need to prove her right to exist in rooms like this one. Then she went to level 2 to have a conversation with Officer Dale Pruitt that he would not find enjoyable. The inquiry began the following morning. Chief Marshal Chambers filed her incident report at 6:45 a.m. before the building opened. She had been awake since 4. The report was 8 pages. It included a timeline of events based on the security camera, footage from the level 4 stairwell camera, which had captured Pruitt's approach, and the general shape of the exchange from a distance. It included her own observations upon arrival. It included Pruitt's statement, taken the previous evening, in which he said he had been doing his job and the woman had refused to comply with a standard credential check, and that, while he acknowledged she had produced some kind of document, he had no way of verifying it on the spot. He had not mentioned the placard. The marshal's report noted this omission in a separate paragraph. The Caldwell PD's Internal Affairs Division received a copy of the report by 8 a.m. Captain Elaine Forster, who ran IA, read it at her desk with a coffee she did not drink. She pulled Pruitt's file. She had pulled Pruitt's file before. 3 times in 6 years. Each time the union had filed a grievance, and each time the grievance had been resolved with a reduction in finding. Forster was not a cynical woman by nature, but she had been in IA for 11 years, and she had learned to recognize the specific weight of a file that had been managed rather than reviewed. This file had that weight. She called the union representative. She told him that the situation had moved beyond departmental jurisdiction. She told him that the officer's conduct had taken place in a federal building, in the presence of a federal judicial officer, and that, as a result, the review would involve the United States Marshal Service and potentially the Office of Professional Responsibility at the Department of Justice. She told him that she was calling him as a courtesy, because it was the right thing to do, but that the courtesy was not an invitation for the union to manage this one. The union rep was quiet for a moment. Then he asked if it was really a judge. She's been on the federal bench for 16 years, Forster said. She has a named courtroom. Her photograph is on the building directory. Her name is on her parking spot. Another silence. He says he didn't see the placard, the rep said. He was standing 4 feet from it, Forster said. We have it on camera. The union rep did not say anything else useful after that. The second investigation, conducted in parallel by the U.S. Marshal Service, found what the camera footage could not fully capture, but what the 4 witnesses, a court clerk who had been retrieving something from her vehicle on level 3 and heard the exchange through the open stairwell door. 2 attorneys who had been passing through the bridge on level 3 and heard the tone of it, and the building's evening security supervisor who had been watching the level 4 monitor when Chambers arrived, could describe with specificity. They described his tone. They described the particular cadence of his voice when he said the word lady. They described the body, language, the closed space, the way he had held the flashlight. They described the moment when he said, "For all I know, you picked that thing up at a print shop," which 3 of the 4 witnesses cited specifically, and which all 3 described in the same terms, not as an accusation of fraud, but as a demonstration of disregard, as a deliberate signal that he had decided she was not credible before she had opened her mouth, and that no credential she could produce was going to change that, because the credential was not the point. The point, all 4 witnesses agreed independently, was that she was in a space he had decided she did not belong in. They were careful witnesses. They used precise language. They had spent their careers in and around a courthouse, and they understood the weight of the record. They did not editorialize. They stated what they had observed. What they had observed was enough. The morning of the first formal hearing was a Thursday, 3 weeks after the parking garage incident. Judge Osei Mensah was on the bench at 8:30 for the early session, as she was every Thursday. Courtroom 14 Bites was her courtroom, high ceilings, old wood. The particular quality of light that falls through tall frosted windows in a federal building in November. It was a room that had been a courtroom for 68 years. It had that weight to it, not the weight of grandeur, but the weight of accumulated consequence, of decisions that had mattered, of arguments that had been heard and weighed and decided, of people who had stood before the bench with their futures in someone else's hands and had received justice or had been failed by it, and in either case had left changed. She took her seat. The room rose and was seated. The first three matters were routine: a scheduling conference, a motion for extension, a plea colloquy that went smoothly and was completed in 20 minutes. She worked through them with the efficiency of long practice, precise, fair, without waste. The attorneys in the room watched her the way attorneys watch a judge they know well, with the specific attentiveness of people who understand that this particular bench rewards preparation and precision, and will not rescue you from your own sloppiness. The fourth matter on the docket was United States v. Pruitt D., Batch 4417. Officer Dale Pruitt walked into courtroom 14 bytes at 10:15 a.m. He was in dress uniform. He had been told to wear dress uniform. His attorney, a man named Gerald Croft, who had represented police officers in disciplinary proceedings for 21 years, walked beside him. Croft was good at his job. He had reviewed the case file. He had prepared Pruitt for this appearance. He had not, because he had no reason to, told Pruitt the name of the judge assigned to the case. He had told Pruitt the case number in the courtroom and the time. Pruitt came through the courtroom doors. He looked at the gallery. He looked at the counsel's tables. He looked because it was the instinctive thing to do when you walked into a room at the bench. He stopped walking. Gerald Croft walked 2 steps ahead before he noticed his client had stopped. He turned around. Pruitt's face had done something complicated and involuntary. His color changed. The dress uniform, which had been doing the work of projecting competence and professionalism, ceased to do that work. He was standing in the aisle of courtroom 14 bytes looking at the bench with the expression of a man who has just understood something he wishes he did not understand. Judge Osei Mensah looked back at him. Her expression was entirely neutral, entirely professional. The expression of a judge at the start of a session, reviewing the parties before her. The courtroom was silent. Not the performative silence of a room waiting for something to happen. The absolute, specific silence of a room that has registered something and is holding its breath around it. The attorneys in the gallery understood immediately. The clerks understood. The marshal by the door understood. They had all been in this building for years. They all knew who she was. They all knew what had happened 3 weeks ago, because these things do not stay contained in a building full of people whose profession is information. They knew. And now, watching Dale Pruitt stand frozen in the aisle of her courtroom, they were watching him understand what they already knew. Croft put his hand on Pruitt's arm. He leaned close and said something in a low voice. Pruitt did not respond for a moment. Then he walked, with the specific mechanical quality of a man overriding his instincts. Through sheer effort, to the respondent's table, he sat down. He put his hands on the table. He looked at them. Judge Osei Mensah waited until he was seated. Then she looked at the docket. We're here in the matter of United States v. Pruitt, case number 14-9743. On respondent's appeal of the administrative finding dated September 4th, she looked up. Mr. Croft, is the respondent prepared to proceed? Your Honor. Croft stood. He was choosing his words with the specific care of an attorney who has just realized the situation has dimensions he was not briefed on. The respondent is prepared to proceed. However, given the circumstances that have come to light, the respondent would respectfully request that the court consider. Mr. Croft? The judge's voice was the same voice she had used in the parking garage. Entirely level, entirely exact. Are you filing a motion for recusal? A pause. Your Honor, the respondent would note that recent events may create the appearance of Mr. Croft. She looked at him steadily. I am going to stop you there because I want the record to be clean. If you are asking me to recuse myself from this matter, you may file a formal motion to that effect. It will be reviewed by the chief judge of this district, who will determine whether recusal is warranted. I will not make that determination myself, because I am not in a position to be both the subject of the recusal question and its adjudicator. That is the procedure. She paused. If you are not filing a formal recusal motion, I am prepared to proceed. What is your preference? Croft looked at Pruitt. Pruitt looked at his hands. Croft looked at the judge. The respondent will not be filing a recusal motion at this time, he said. A murmur moved through the room, not loud, not disruptive, the sound of people absorbing something. What happened over the next 4 hours was not a spectacle. It was a proceeding. It was conducted with the methodical, formal precision that federal proceedings require. and Judge Osei Mensah conducted it exactly as she would have conducted it if she had never seen Dale Pruitt in her life. She gave Croft full latitude to present the appeal. She asked questions of both parties with equal sharpness. She pushed back on overreach from the government's attorney with the same precision she applied to Croft's weaker arguments. She ran a clean proceeding. But the record was what the record was. 9. Use of force complaints in 6 years. 4. Citizen misconduct reports. A pattern that the government's attorney laid out with the kind of documentary specificity that is available when a federal block agency reviews a file without the constraint of a union grievance process. A pattern that Croft, to his credit, did not try to characterize as unrelated incidents. He argued, instead, that each had been resolved through the applicable process, that his client had complied with all departmental requirements, and that the administrative finding had been procedurally flawed. The judge listened to all of it. Then she looked at the file in front of her. Then she looked at Pruitt. "Officer Pruitt," she said, "you have been on the force for 6 years. In those 6 years, you have been the subject of 9 use of force complaints and 4 misconduct reports. The administrative finding that you are appealing concluded that your conduct in the October incident demonstrated a pattern of racially motivated escalation and that your continued assignment in public contact roles presents an unacceptable risk of harm. Your attorney argues that the finding was procedurally flawed." She set the file down. "I have reviewed the procedural record. I have reviewed the complaint history. I have reviewed the body camera footage attached to the government's brief." She paused. The room was absolutely still. "The finding was procedurally sound," she said. "The appeal is denied." She picked up her pen. She wrote. She signed. "Furthermore," she continued, "in light of the documented pattern and the severity of the October incident, this court is issuing a supplemental order requiring Officer Pruitt to be removed from all public contact assignments. Pending a comprehensive behavioral review by an independent panel, this order is effective immediately and is binding on the Caldwell Police Department as an employer subject to federal non-discrimination requirements." She looked at Pruitt one more time. "Mr. Croft, your client has 30 days to comply. The government's attorney will coordinate with the department on implementation." She set her pen down. "We're adjourned." The gavel came down once. It was not loud. Federal courtrooms do not require loud gavels. They require the right kind of quiet. And this was that kind of quiet. The quiet that follows a decision that has been made properly, with full authority, without cruelty, and without any particular interest in how it would be described afterward. Dale Pruitt sat at the respondents' table for a moment after the room began to move. Croft was already gathering papers, already calculating next steps, already in the professional mode of an attorney managing an outcome rather than feeling it. Pruitt was not yet in that mode. He was still sitting with his hands on the table, looking at the bench where the judge had been, which was now empty because she had left through the side door as judges do, quietly and without ceremony, already moving on to the next matter. He had walked into a parking garage 3 weeks ago and decided, in the first 30 seconds, that a woman with a tote bag didn't belong on a restricted level of a federal building. He had decided it based on what he could see. And what he could see had told him everything he had already decided to believe. He had refused to look at the placard. He had refused to look at the credential. He had refused, at every step, to let the actual information disrupt the story he had already written. The story had been wrong. It had been wrong in the parking garage, and it was wrong in the courtroom. And the wrong was not going to be resolved by a grievance process this time. The federal order was binding. The removal from public contact assignments was immediate. The behavioral review was not the kind of review that union representatives managed over a negotiating table. It was the kind that produced a report that followed a person's name through every subsequent application they ever filed. He stood up. He picked up his hat. He walked out of courtroom 14 bites. The second twist arrived 2 days later, on a Saturday morning, in a document that the court clerk delivered to Judge Osei Mensah's chambers by hand because it was not the kind of document that should wait in an inbox. It was a filing from the Department of Justice Civil Rights Division. They had been watching the Pruitt case. They had been watching the Caldwell PD's broader complaint disposition record. The Pruitt file, elevated to federal review by the Marshal Service's involvement, had been the thread that let them pull the larger pattern. What they found was what Captain Forster had suspected for years and had not had the federal standing to pursue. a systematic practice of first-level complaint closure managed through the union grievance process that had effectively functioned as a suppression mechanism for misconduct. Reports against a specific subset of officers, almost uniformly those with documented histories of racially motivated conduct. 11 officers, 6 years of records, 34 complaints that should have resulted in formal findings and had instead been resolved as supervisory counseling at the first level, with the union rep present and the subject's disciplinary records clean. Pruitt was one of the 11. He was not the worst of them. The DOJ filing requested an emergency conference with the chief judge. It also requested, in a footnote that was technically procedural but substantively significant, that Judge Osei Mensah be consulted in her capacity as the presiding judge in the matter that had triggered the broader review. She read the filing on Saturday morning in her kitchen with her coffee. She read it twice. She set it on the table. She thought about Spot 4. She thought about the 16 years of mornings she had pulled into that spot, walked to the elevator, crossed the bridge, gone to her courtroom. She thought about all the time she had moved through that building as if it were hers, which it was, in the specific and hard-won sense of someone who had earned every square foot of it, and how she had also moved through it with the constant low-level awareness that earning it had never been sufficient proof of belonging. She thought about the placard. He had been 4 feet from it. He had refused to look. The emergency conference with the chief judge happened on Monday. Judge Osei Mensah attended in her formal capacity as a consulted party. She said very little. She answered the questions she was asked. She was precise and professional and gave the chief judge and the DOJ attorneys exactly what they needed from her and nothing beyond it. What she said, when asked to describe the parking garage encounter for the record, was 9 sentences. She stated facts. She stated what she had shown him and what he had declined to examine. She stated what he had said, including the specific phrase, "For all I know, you picked that thing up at a print shop," which she repeated verbatim, without emphasis. In the same tone she used to read a statute into the record. She did not describe her response to it. She did not need to. The 9 sentences were sufficient. When she finished, the room was quiet for a moment. The chief judge looked at the DOJ attorney. The DOJ attorney looked at his notes. "Your Honor," the chief judge said to Osei Mensah, "thank you. That will be sufficient for the record." She nodded. She gathered her materials. She stood up. At the door, she paused. She turned back. The room looked at her. "I want to be clear about something," she said. She was not speaking as a consulted party. She was speaking as herself, which was a thing she rarely did in these rooms. This case matters because of the pattern, because of the 34 complaints and the 11 officers and the 6 years. That is the thing that needs to be fixed. What happened to me in the parking garage was unpleasant, and it was wrong, and it is on the record. But I have been practicing law in this district for 22 years, and I can absorb an unpleasant evening. She looked at the table. The people who filed those 34 complaints could not absorb the outcomes as easily as I can absorb this one. That is the asymmetry that matters. I want that in the record, too. She left. The room held its silence for a moment after the door closed. Then people began to move, because there was work to do, and she had just told them exactly what the work was. The Caldwell PD's consent decree, negotiated over the following 4 months with the DOJ, required an independent civilian oversight board, a revised complaint review process, mandatory body camera retention for all public contact officers, and an external conduct review of the 11 flagged officers. 3 of them, including Pruitt, were placed on administrative suspension pending the outcome of the review. 2 eventually resigned. The others returned to modified duties under monitoring conditions that, for the first time in the department's history, had teeth that could not be pulled by a union grievance. Captain Forster, who had spent 11 years watching files get managed rather than reviewed, became the department's liaison to the oversight board. She was, by her own account, the best person for the job and the last person who should have had to want it. She did it anyway. She did it the way people do things when the alternative is that no one does them at all. Gerald Croft, who was a good attorney and an honest man, filed no further appeals on Pruitt's behalf. He told a colleague, some months later, that he had represented police officers in misconduct proceedings for 21 years, and that the Pruitt case was the one he thought about when he was trying to decide whether his work made things better or worse. He said the answer he had reached was that it depended entirely on how honest you were with your client about the difference between a defense and a justification. He said he had not always drawn that line clearly enough. He said he was drawing it more clearly now. 6 months after the parking garage, Judge Ose Mensah had a conversation with her clerk, a young woman named Priya Subramaniam, 3 years out of law school, who had clerked for her for 2 of those years and was preparing to leave for a fellowship at the end of the term. They were in chambers at the end of a Thursday, which had always been the day that ran long. Priya was boxing up research materials. The judge was reviewing the following week's docket. "Can I ask you something?" Priya said. "Yes." "When you were in the parking garage, and he said—" She stopped. "When he said the thing about the print shop, what did you—" She stopped again. She was trying to find the right question. She was 26 years old, and she had been watching this woman for 2 years, and she had learned a great deal about how to be precise. And she was discovering that precision was difficult when the thing you were trying to be precise about was this particular thing. Judge Ose Mensah looked up from the docket. "What did I feel?" she said. "Yes." The judge was quiet for a moment. She looked at her desk. She looked at the photograph on the corner of it. Her mother, her daughter, both of them at the judge's swearing in. 16 years ago, her mother's hand on her shoulder. "Tired," she said finally. "I felt tired." She paused. "I have been explaining myself in rooms that were supposed to be mine for 30 years. I am very good at it. I have built a life that is genuinely good, with work I am genuinely proud of. And I am not asking for anyone's pity about the cost of it." She looked at Priya. "But I am tired, and I think being tired about it, without performing something other than tired, is the most honest thing I can offer you." Priya nodded. She was quiet for a moment. "It changed things," she said. "The case, the DOJ investigation. What happened after?" "Yes," the judge said, "it did. Because of you. Because of 34 people who filed complaints into a system that buried them." The judge said, "I was the one the system couldn't bury. That's not the same as being the cause of the change. I was the occasion. They were the cause." She picked up her pen. "Put that in your notes for the fellowship." Priya smiled. She put it in her note. The judge went back to the docket. The Thursday ran long. The work continued, as it always does, past the hour when reasonable people go home, in a room with old wood and high ceilings and the weight of 68 years. Suffer reggae, decisions that had mattered, some of them more than anyone intended and some of them less. All of them made by people who came to this room every day and tried to do the right thing with what they had. That is what courts are. That is what they have always been. Not perfect, not above the failure of the people inside them, but capable, when held accountable, of being better than they were. Capable of looking at the record and deciding, one case at a time, what the record requires. If this story stayed with you, if you believe that accountability has no rank exemption, and that the people who keep fighting the same fight for 30 years deserve to see the fight amount to something, share it with someone who needs to hear it. Hit the like button, subscribe, and turn on notifications, because we will be back with another story about the people who hold the line. We will see you next week. The DOJ filing was not the last surprise the Pruitt case produced. 3 weeks after the emergency conference, the civil rights attorney handling the broader investigation called Captain Forster with something the records review had surfaced that had not been in the original file. One of the 34 buried complaints had been filed by a woman named Marlene Cousins. She had filed it 4 years ago, in writing, with 3 pages of documentation. A photograph of the bruising on her wrists from where Pruitt had restrained her against a chain-link fence during a traffic stop in the east end of the city. The complaint had been filed. It had been logged. It had been routed to first-level review, and it had been closed at first level in 11 days, with the notation, "Officer denies conduct. Insufficient evidence to proceed. Supervisory counseling recommended." Marlene Cousins was 62 years old. She was a retired postal worker. She had worked the same route in Caldwell for 29 years. She had filed the complaint because her daughter had told her to file it, and she had filed it, believing, because she was a woman who still believed in systems even when systems failed her, that filing a complaint was the right thing to do and that the right thing would lead to a right outcome. It had not. She had never heard back after the initial acknowledgement. She had not been told the complaint was closed. She had not been told the finding. She had not been told anything. She had filed her 3 pages of documentation and her photograph, and she had waited, and the system had folded her experience into a category called insufficient and moved on. The civil rights attorney told Forster. Forster told the DOJ lead. The DOJ lead called Marlene Cousins. She had not expected to be called. The call lasted 45 minutes. The DOJ attorney listened. He did not interrupt. He did not explain, in the way that attorneys sometimes explain, that the process had been followed even if the outcome had been wrong. He listened to what she said about the 11 days it had taken for her complaint to disappear and about the year she had spent afterward not calling the police when she needed to call the police, and about the specific quality of feeling that comes from believing in a system and being shown, efficiently and without ceremony, that the system does not believe in you. He wrote it down. Her testimony became part of the DOJ's formal record. Her name was in the consent decree as a named complainant, with the explicit notation that her 2020 complaint represented a documented instance of the systematic suppression pattern that the decree was designed to address. She did not come to the courthouse when the consent decree was signed. She did not see her name in the document until her daughter printed it out and put it on the kitchen table. She read it. She read her name and the date of her complaint and the phrase documented instance of systematic suppression, and she sat at her kitchen table for a while, not saying anything. Her daughter asked if she was all right. She said, "I filed that thing 4 years ago. I thought it went nowhere. It had gone somewhere. It had just taken 4 years and a federal judge in a parking garage and a DOJ review to get there. That was not a satisfying timeline. It was, however, the timeline that existed, and the names that got there were the names that mattered." Judge Osei Mensah learned about Marlene Cousins from the DOJ lead, who mentioned her in passing during a status call. He said her name and the year of the complaint and the brief summary of what had happened. The judge listened without speaking. When he was done, she said she would like to write the woman a letter. Not a formal letter, a personal one. The DOJ attorney said that was outside the scope of the proceedings. She said she understood that. She said she was going to write it anyway. She wrote it that evening. 3 paragraphs. She said that the record had found her. She said that what had been done to her complaint was wrong and that the wrong was now documented and that the document had weight that could not be removed. She said she was grateful, though the gratitude came too late, and that the work of the consent decree was partly in honor of the people who had filed and been failed before the system found its way to accountability. She did not sign it with her title. She signed it with her name.